Hello, everyone, and welcome to the KJH Insights podcast. I'm Sarah Bull, Managing Partner at KJ Harrison Investors. Thank you for joining us. Today's episode is part of our Women and Wealth series, where we explore financial topics that we believe matter most to women through all of their life stages and transitions. This show really aims to educate and inspire women to make wise decisions around their wealth. Today's conversation is titled Protecting Your Legacy from Lasagna Ladies. What do we mean by Lasagna Ladies? It's a light-hearted phrase that underscores a sobering reality. Imagine this. You pass away first, leaving your husband grieving, and before not too long, a new companion arrives with casseroles. One day, she's at your door with dinner, and the next, she's in your home and has access to the estate you've worked so hard to build for your children. Without careful planning, your legacy can unintentionally shift away from your family and towards someone else. So to help us explore this topic, I'm joined today by Lori Duffy, an estate lawyer who specializes in estate planning and works with families to safeguard not only their assets, but also their values and wishes. Lori, welcome. Thank you for joining us. And can you start by telling us a little bit about your practice and how you help families?
Thank you, Sarah, and thank you for inviting me to participate in this podcast. As Sarah noted, she and I have done several presentations over the years to many of our clients to ensure that the importance of a proper estate plan is understood. I practice solely in the area of estate planning, which includes advising on and preparing wills, powers of attorney for property and personal care, a variety of types of trusts, and any other documents that are needed to ensure that what you would want to happen to your assets and how your family and friends will benefit from your estate is clearly expressed, is tax efficient, and often, most importantly, it's enforceable.
That's great, Lori. Thanks. That's a great introduction, and I think really helps our listeners understand how you can provide advice here today. So, Lori, in terms of setting the stage, when we say lasagna ladies, what scenarios are we really pointing to in terms of estate planning?
Well, first, I want to take a step back and define what is a spouse. You may be a spouse as a result of a legal marriage, or you may be a common law spouse. Both types of spouses have specific support and sometimes property rights, but those rights are very different depending on your status. Common law spouses do not acquire property rights, but they may be entitled to support. The Family Law Act clearly distinguishes between these two types of spouses. Married spouses may claim a right to a division of property as well as to support. This becomes very important if the spouse dies without a will. Where their property will go depends very much on the type of relationship he or she is in. I do love your use of the term lasagna ladies. You can just see the lineup of casseroles down the street when a man becomes single. When a woman becomes single, I'm not so sure that there's food. Maybe there's the offer of household repairs or grass cutting or tennis lessons, but I'm not sure. In any event, the term we often use for a marriage after death is a predatory marriage. This occurs when a person becomes romantically involved shortly after the death of their spouse and they are suddenly alone, perhaps cooking for themselves or doing their own laundry after a lifetime of being cared for by a wife. And they suddenly become romantically involved with this person that appears and is magically doing all of those things and adding a new element of comfort and attention that they were suddenly missing. Sometimes the goal of the lasagna carrying people is purely friendship, perhaps because their spouse has also died, or perhaps they simply want to help a person in a time of need. But often it is because they do see a source of income and assets and a lifestyle that could become theirs if they marry and he dies first, and to spend until that event should occur. And as your statistic, which you provided to me, of 29% of the people in these kind of relationships are men, it does seem to happen more often to men than women. So the question then is the issue in this predatory relationship only about money? A lot of time it is, but I have also seen it influence changes in religion that can affect and upset children and mutual friends. There can be changes to a family home held in the family for many decades to accommodate this new spouse. This new spouse suddenly doesn't like many of your family heirlooms, is tossing out those things that bring back memories, and you may be suddenly having to share the family cottage with new people. All of this can be very hurtful and stressful to the remaining family members who, remember, have probably just lost a parent. So maybe dad seems to like his new step grandchildren or stepchildren more than you. All of these issues may arise as a result of this new person entering your parents' life or your spouse's life as the predatory spouse.
I think that's a really great summary of it. And I wanted to just drill down then on some of the things that you said here. So let's start about what you said about the family home and getting rid of some of the favorite family heirlooms. So, what are some of the examples of where women have thought her will or even promises that her and her spouse discussed were enough, but that it didn't, in fact, protect her wishes? Can you walk us through maybe even an example of something like that?
Yes, happy to. One of the saddest cases that I've been involved with started with a couple who had been married for close to 60 years. The wife died quite unexpectedly. They had recently moved to a condominium in Toronto to be closer to two of their children. Their third child lived in another city in Ontario. They had both worked their entire lives. They had actually inherited significant assets from their respective families, and they were very well off. These assets included a collection of group of 7 paintings. After the death of the wife, husband became very lonely, and his children in Toronto were busy with their work and their own children. Though they did try and see him weekly, he often said the days were very long, and he was clearly lonely. He was eventually persuaded by the child who was living in another city and who had recently retired to move to that city and to move into a senior's residence where there'd be more activities and people his age to make new friends with, and for sure there would be better food. I think she was trying to avoid the Lasagna Ladies in his condominium building. Well, she was very right. She was very right that there were people in this residence to make friends with. And there was one in particular who lived in a much smaller suite than his, right next door to his. She had two adult children of her own. They both lived outside of Canada, and it became clear that her children were having to support her and that they weren't really happy about it. She was also in perfect health, another factor that her children were not happy about. She met my client, let's call him Jim, not his real name, and they quickly became friends. Her children actively encouraged the relationship. Jim's children did not. And before he knew it, he had apparently proposed, although he didn't actually recall having done that. And a wedding was being planned by her children and the retirement home. They all thought it would be good publicity. Come and live here and start over again. Meet your new mate and have a fun time, or some other similar tagline. They were less encouraged about it when I then explained to them the effects of this kind of a marriage on their estate planning. I went to visit Jim at the residence and I suggested that he enter into a marriage contract. I explained how that could be used to preserve the planning that he and his late spouse had done, and it would protect his children and grandchildren. To quote him, he thought that would be a splendid idea. By the end of the week, however, I had a call from him to tell me that the idea of such a contract was offensive, that his fiancée was very upset about it, and it had almost cost him this wonderful relationship. My bells went off, as did the bells of his children. And I was also worried about his capacity. He had received a diagnosis of very early onset dementia, and he was becoming very forgetful. At that point in time, prior to some legislative changes that have occurred in 2021, a will was automatically revoked by marriage. Now, of course, it is not automatically revoked. It will stay in its current state. But back then, had he married this woman, the will that he matched his late spouse's will was no longer going to be effective. So that meant clearly that if he did get married, his estate that was left to his children would now be revoked. And if he didn't do a new will, the new wife would be entitled to a share of his estate on death pursuant to our intestacy laws. At the moment, those laws would provide that she would get the first $350,000 of his estate. And because he had 3 children, she would also get 1/3 of the residue. I met with him again and suggested that this time we prepare an alter ego trust to hold his assets. This trust would mirror his current will and would allow his children to be the trustees and help him with the management of his money and investments and paying of his bills. He agreed with this, and I was satisfied that he had the requisite capacity to provide these instructions and that his attorneys for property, who had also already been acting for him, also agreed with its use. I immediately prepared the necessary documents. We settled the trust, transferred the bulk of his assets into it, and proceeded to manage these things on his behalf. The next thing we knew, they were secretly married by a friend of her children. We never did find out if this marriage was a real one, but it didn't matter because sadly, the marriage did not last. It ended almost immediately upon discovering that Jim's assets were held in a trust. Her children moved her to a less expensive residence, and we never heard from her again. I'm not even sure that he got a lasagna out of it, to be perfectly honest, Sarah, but it was an interesting episode.
It doesn't sound like he did, but isn't that exactly why we're doing this podcast, right? And it's really interesting because I think most people would have reciprocal estate plans. So just making sure we all understand. So based on the new law from 2022, if you have a reciprocal estate plan, basically naming your spouse inheriting your assets and then upon his death going to the kids, if he does remarry or your partner remarries, then those wishes stay in place. Is that correct?
That's correct. So the will isn't automatically revoked by marriage, but the spouse would still have a right, the new spouse, to elect against the will and to take what he or she would have been entitled to on divorce. So they would still have a claim against the estate as a result of the marriage. Living common law, though, if they don't actually get married, they would not have that claim. They may have a dependence relief claim for support from the estate, but they wouldn't have the same property rights that a married spouse would have. So even if you don't change your will, and as the law now says, it's not immediately revoked, that doesn't mean that the new Lasagna Lady spouse doesn't have a claim in the estate.
Okay. And common law is after 3 years?
Yes. For family law purposes and death, it's 3 years. It's 1 year for income tax.
Yeah. And so using the example of Jim, it sounds like what you put in place were some really practical safeguards. And so for our listeners today, whether they're worried about their parents, because I think this is a really good example of the alarm bells going off, not only for you, but for the kids, or whether the women on the call are thinking about themselves, talk about some of those estate planning strategies or safeguards that can be put in place to reduce this kind of risk.
Exactly. So I do think that we as women need to think about how we can arrange our assets and our estates to ensure that our wishes will always be respected should your spouse remarry or live in a common law relationship. First of all, I think the first step that you have to take is to really understand what you own and how you own it. When I meet with our clients, we usually have them complete a checklist outlining those assets and how they're owned. And it usually takes us 2 or 3 shots at this checklist to get the actual ownership right. Sometimes they will think they have designated beneficiaries on various registered plans. Sometimes they think they jointly own something. Sometimes they think they own it alone. And they're often surprised when we do the necessary searches or look at the account forms to see that their assets and their holdings are not necessarily registered as they think they are. So the first step is figure out what you own and how you own it. Then we should take a look at how those assets that flow outside of your will by reason of being jointly owned with your spouse or by having your spouse listed as a designated beneficiary. This is usually done as a goal for tax savings and for providing for your spouse, but it may not necessarily always be your goal. So, in my view, this is something that you must really discuss with your spouse. I don't want to make everyone paranoid about this and destroy a good tax efficient estate plan that you've put in place because of a fear that there may be a second spouse in your husband's future. But you should really consider it. If you can, try and discuss it with your spouse. We often find out that he may also be worried about the tennis pro in your future. It's not just the lasagna lady. So if you can, have a good open discussion about it. So, what would be sort of a good action plan to think about when you're having this conversation? Well, the first thing to think about is that when you retain a lawyer with your spouse, it's usually a joint retainer. And that means one of you can't later call me and say, listen, I know when I was in that meeting with you, I agreed to leave all of this to X, but I really don't want to do that. And I don't want my spouse to know. So can you change that for me and I'll come in and sign it? I can't do that. I have to tell he or she that I can't take that retainer on, that I should notify her of this change, and that he would have to retain another lawyer to do this. So that's one thing you need to consider. Have you entered into a joint retainer with your lawyer? Another option to think about, and again, this will depend on the person's age. So if you or the parent, if that's who you're concerned about, is over the age of 65, you could consider using a joint partner trust during your lifetime. So that would be like the alter ego trust that I described for the client who was single. The couple version of that is a joint partner trust. So normally when you roll assets into a trust, you trigger capital gains tax and the tax becomes payable when you do the transfer. But the Income Tax Act was amended a few years ago to provide that if you do such a trust and you're over the age of 65 and you're doing it as part of your estate plan, you can roll as many assets as you wish into this alter ego or joint partner trust without triggering any tax. You can name who the trustees will be, and you can insert into that document who the ultimate beneficiaries will be. So, this can be very useful if you are of the age to use it. But again, it is still capable of being revoked. And one of my concerns is that the residual clauses may change depending on who those ultimate beneficiaries are. So it is a good tool, and that's the tool that I used when I talked about Jim, and it's something I think you should consider. The most common way to try and protect your assets, and those again are those assets that you own alone, not those that are jointly owned or where you've designated your spouse, is to use a spousal trust in your will. When using this means that you have the same tax rollover and your spouse has all of the benefits of using the trust monies, and you get to decide whether he just gets the income from it, which he has to get in order to qualify as a spousal trust, or whether he should have a right to access some of the assets held in the trust. One thing that a lot of people do is they set up a spousal trust and then they name the spouse as the only trustee. That means he can do all sorts of things without anyone knowing until he's dead, and it could be empty. So I usually recommend if you're going to use a spousal trust to add in a second trustee who may be one of your children, maybe someone that you trust to ensure that the surviving spouse respects the terms of the trust. This is also very efficient for tax planning, but it does require some extra tax returns and accounting costs to maintain it. The other thing that I'd like people to think about is we focus sort of on the big assets, but you should also consider specific gifts of some of your other valuables like jewelry, artwork to your friends or to children to ensure that the next spouse does not get it. I would always suggest you be very specific about these kind of wishes. So, for example, the group of 7 paintings, had he gifted some of those to the children on his wife's death, there might have been some tax payable. At least those paintings would have been protected and wouldn't be in the girlfriend's children's new house.
Is there anything else we should think about?
The other thing to think about is the use of family trusts. So you could consider preferring your children on certain of your assets and going back up to designations. We tend to always put our spouse as designations on registered accounts, like our RSP, things like that. The TFSA, we almost automatically do it because there is some tax advantage to having your spouse listed as the successor owner. But that may be something that you want to just designate straight to the kids. If your husband doesn't need or your spouse doesn't need the TFSA to survive and it's not going to really affect his entitlement, you might just designate your kids on that to ensure that they get at least something outright on your death. Another thing that I actively encourage all of our clients to do is give it away now. If you are older and you're not using all of your assets, why not benefit the kids and friends that you like? I always ask that you do a formal deed of gift just in case their marriage breaks down and we want to be able to establish it was a gift and not something that was earned by them to cut their spouses out. But give it while you're alive if you can. The next item, if you do not have a marriage contract and if you do not leave a gift to your spouse, as we noted, your spouse may elect against your will and he would take what he would have received had your marriage ended during your lifetime. So if you are trying to not leave gifts to your spouse, make sure you consider what his family law rights would be because we don't want that spouse to elect against the will and head into court to try and have a resolution of all of this. The other thing I want you to think about in doing this is what is the capacity for your surviving spouse to marry? All of us know about people relying on powers of attorney and other forms when dementia does hit. But I just want to point out that a court decision of a few years ago suggested that the capacity for entering into a contract of marriage is a very simple one, and it is not a high bar to pass. It does not require a high degree of intelligence to comprehend, as what the judge said. And so, even though you may not have the capacity to write a check or to pay a bill, you may have the capacity to marry, and that's always very concerning. Another item that you might consider is a letter of wishes. These are not contractually binding on them, but they often have moral suasion. When you read a letter from your mom after your mom has died saying, do not give this painting to X. So it could be very helpful. The big one is, get good advice from people who specialize in this area. There are lots of people out there who do a $35 will. And I don't mean to criticize those lawyers or paralegals, but if you've got these kinds of assets, you want to get good advice and you want to get someone who specializes in it. The laws are constantly changing in this area. There's lots of case law coming out as our generations get older. So really be careful about selecting good professionals. And my last little bit of advice is update or at least reread your documents on a regular basis. Don't sign them with the lawyer and then lock them away and never think about them again.
How often should estate plans be revisited?
I actually have one client. They review all of their documents on every wedding anniversary that is an even number. So if it's their 10th wedding anniversary, their 12th, or their 14th, they go to dinner, usually Scaramouche, and they bring their documents with them and go through it and chat about what they want to do. And they see how much they've accumulated in this marriage and how successful or not successful they are. But they do it on their even numbered wedding anniversary. One of the changes that people will often need to make and consider more frequently is if they do have minor children, who those guardians are going to be, because those guardians are going to change as your kids age. So the person who you thought would be great with them when they're in nursery school may not be the person who could handle them now that they're teenagers. So it never hurts to review them. It doesn't mean you may need to change anything, but just review them from the perspective of where your life is now.
That's great. Such good advice and really good action steps that our listeners can take almost immediately after this podcast. So it's excellent. I guess the one thing that I would say too is just this whole concept of having the discussion about remarriage with your spouse and having the discussion with your children and be very clear about your wishes. Because I thought that was super interesting what you said about the paintings. It's hard to ignore that wish if it had been articulated somehow and communicated. That's great. Well, Lori, any last pieces of advice for our listeners?
Yeah, I think it's coming at it from a bit of a cynical approach. Not all second, third, or fourth marriages are to predatory spouses. Some may be very happy unions. They may be liked by other family members. However, it's rare that your spouse's children from your prior relationship are ever really your children. And it's sometimes hard not to prefer your own over your spouse's, no matter how wonderful everyone is. So, as you've just said, Sarah, I think it's really important to figure out how to keep things separate if that's important, figure out who's sharing expenses. Is a marriage contract appropriate? And is there a significant age gap? So if your new spouse is closer in age to your children and you even do the proper thing and leave it in a spousal trust, like, will your children ever inherit from you? So how will they feel about that? How will they feel about the other family, young kids using the family cottage? Again, communication, planning, and talking so that there's no surprises is really important. Your kids may never be the new version of the Brady Bunch family, and maybe I'm aging myself, but at least you can try and work to ensure that we all don't end up in court.
Yeah, no, I love it. And I think that is the end goal, right? So thank you, Lori. I think today's conversation really reminded us that protecting your legacy is more than just about money. It's about ensuring that your children and your values and your family's well-being are carried forward, no matter what, as you said, life brings. It's not linear, is it? And the truth is, men are more likely to remarry, and without proper planning, your legacy can be unintentionally rewritten, so to speak, as you've talked about with Jim. So, in other words, the Lasagna Ladies could end up with access to the estate that you built or carefully planned during your lifetime. But as you've said, the right estate plan or the right estate planning strategies and thoughtful conversations and a trusted team of professionals can help you take control of your legacy and provide clarity and peace for you and your family. So, Lori, thanks for that great advice and for sharing your expertise with us today. And thank you to our listeners for tuning in. If you enjoyed this episode of Women in Wealth, please subscribe and share it with someone that you care about. Until next time, I'm Sarah Bull and look forward to speaking to you again soon.
This podcast is produced solely for informational purposes and is not to be construed as an offer to sell or the solicitation of an offer to buy a security. The information herein is based on sources we believe to be reliable but is not guaranteed by us and does not purport to be a complete statement or summary of the available data. Any opinions expressed herein are statements of our judgment on the recording date and are subject to change without notice. Any unauthorized use or disclosure is prohibited. Receipt and/or review of this presentation constitutes your agreement not to reproduce, display, modify, distribute, transmit, or disclose to others the content, opinions, conclusions, or information contained in this podcast.